attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a multi-part law cast discussing Regulation A+. The new Regulation A+ rules took effect on June 19, 2015. Tier 1 of Regulation A+ allows for a raise of up to $20 million in any 12-month period, and Tier 2 allows for a raise of up to $50 million in any 12-month period. Issuers may elect to proceed under either Tier 1 or Tier 2 for offerings of up to $20 million. Today I am discussing the ongoing reporting requirements for both Tier 1 and Tier 2 offerings. Both Tier 1 and Tier 2 issuers must file summary information after the termination or upon completion of a Regulation A+ offering. A Tier 1 company will need to file certain information about the Regulation A offering, including information on sales and the termination of sales on the new Form 1Z exit report, no later than 30 calendar days after termination or completion of the offering. Tier 1 issuers will not have any additional ongoing reporting requirements. Tier 2 companies are also required to file certain offering termination information and would have the choice of using the Form 1Z or including the information in their first annual report on new Form 1K. In addition to the offering summary information, Tier 2 issuers are required to submit ongoing reports, including an annual report on Form 1K within 120 days of the fiscal year end, and a semi-annual report on Form 1SA within 90 days of the end of the semi-annual period, and current event reports on Form 1U within 4 days of the triggering event, and notice of suspension of ongoing reporting obligations on Form 1Z. All filings are made electronically on EDGAR. The ongoing reporting for Tier 2 companies is less demanding than the regular reporting requirements under the Securities Exchange Act, but still details determine diligence. There are fewer Form 1K items and only semi-annual Form 1SA rather than the quarterly report on 10Q, and fewer events triggering a Form 1U compared to a Form 8K. The rules also provide for a suspension of reporting obligations for a Regulation A+ issuer that desires to suspend or terminate its reporting requirements. Termination is accomplished by filing a Form 1Z and requires that a company be current in its reporting requirements, have fewer than 300 shareholders of record, and have no ongoing offers or sales in reliance on a Regulation A+ offering statement. Of course, as previously discussed, a company may file a Form 10 or Form 8A to become subject to the full Exchange Act reporting requirements. The ongoing reports will qualify as the type of information a market maker would need to support the filing of a 15C211 application. An issuer that completes a Tier 2 offering could proceed to engage a market maker to file a 15C211 application and trade on the OTC markets. The issuer would qualify to trade on the OTC Pink or, effective July 10th, on the OTC QB. However, unless the issuer has filed a Form 8A or Form 10, they will not be considered subject to the Exchange Act reporting requirements for purposes of benefiting from the shorter 6-month hold for Rule 144. I'm Securities Attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.